The sociological theory of law is likewise another prominent theory that underlies jurisprudence. And the sociological theory of law gained prominence from the mid 19th century. Now, one of the most ardent supporters of the sociological theory of law was a man called Eugene Ehrlich. And Eugene Ehrlich opined that law is based on what is referred to as facts of law, which underlines how people acted. So in essence, the sociological theory of law is of the opinion that laws should be primarily determined by how people act in a society, the conduct of people in a society, the behavior of people in a society, so to say. So I'm explicating on the sociological school of law as put in place by Eugene Ehrlich. So the position is that for a law to be a law, then that law must actually be regulated, or primary consideration must be given in the making of that law to the behavior of people in the society, the conduct of people in the society, the mannerism of people in a society. So in essence, the way the society acts determines the kind of law that will be put in place. So according to Eugene Ehrlich, in a situation where there is a vice or a trend in a society, so that vice, that trend, that behavior or that mannerism actually, develop, or it instigates the putting in place of a particular law that regulates whatever action it is that the people are exhibited or the people are exhibiting in the society. So he was of the opinion that in a situation where the society, by its actions, fails to acknowledge a law, then the law is doomed as a method or as a means of social control. So looking at the sociological school of law by Eugene Ehrlich, once again, he was of the opinion that the law should be influenced, the provisions or the development of laws should be influenced by the conduct, the behaviors, or the mannerisms of people in a particular community or in a particular society. There's, however, been a couple of criticism that has been levied against the sociological school of law. One of these criticism being that now there are certain instances where the law regulates conduct of individuals, contrary to the postulation of Eugene Ehrlich that states that the behaviors or the actions of individuals regulate the law. There are certain times that the law goes in time. The law foresees certain acts, certain actions, and the law provides a means of curbing such action even before the action or the conduct or the mannerism eventually gets to happen. However, according to Eugene Ehrlich, he was of the opinion that mannerism and conduct is what influences the law itself, which has been abrogated by this particular criticism. In several circumstances, in several situations, the law foresees, the law seeks itself particularly to curb certain acts, certain conduct, or certain mannerism that may be considered as detrimental to the society. Another criticism against the sociological school of law is that it is quite risky, so to say, to go with the flow. Just because every other person is disobeying the law would not excuse an offender. who is caught and is being made a scapegoat. Now, there is another variant of the sociological school of law. This is propounded by Professor Roscoe Pound. And Professor Roscoe Pound was the former dean of Harvard Law School. So according to him, he said there are limited resources in the society and thus numerous competing claims to these resources. In Roscoe Pound's opinion as regards the sociological school, so he gave his own opinion, which is contrary to what Eugene Ehrlich actually propounded. And in his own opinion, there are numerous resources in the society. And the existence of these numerous resources, the existence of these limited resources, has actually necessitated competing claims to the existence of these resources. Therefore, it is the aim of the law to balance and find a way to reach a compromise with these competing claims in such a way that these competing claims will cost the least harm in the society. And this is done instrumentally through the positioning of courts and interpretations to laws and statutes that have been put in place. So, going over the proposition of Eugene Ehrlich once again, Eugene Ehrlich was of the opinion that the conduct of people, the mannerisms of people, or the actions of people influences the law. However, one of the criticisms against this school is that the law, most often than not, seeks to influence the conduct and mannerism of people instead of waiting for the mannerism or the conduct and actions of people to influence the law itself. And likewise, it might be very detrimental to just go with the flow, in the sense that the fact that a person is disobeying the law does not give justification to another person to do the same thing. And this is the presupposition of the sociological school of law.